What's going on, everybody? TRAE4JUSTICE back in the building, coming at you guys with the long-awaited day 14 of the Darrell Brooks trial. No surprise, I've been gone for a long time. If you saw my community post, which if you didn't, it's completely fine. I basically had a next door neighbor that was exactly like Darrell, and what I mean by that is he seemed like a very unhinged guy. I might put up a separate video about it, but honestly, I might not. The main thing I just want to say is thank you all so much. Like, you guys have no idea how much your comments and everything were really helping me through that entire situation as well. Like, even my mom, she reads the comments that you guys leave sometimes, and sometimes I just read them to her and she's like, man, this is beautiful. Like, she's even in disbelief sometimes. And so I really wanted to start off on that note by saying thank you all from the bottom of my heart. Like, I really mean that. Okay, so far on day 14, we spent a lot of time with Judge Darrell basically reading the list of charges to the jury, and basically her explaining the process to them when it comes to deciding whether or not Darrell is guilty or innocent, which he's definitely guilty. Now, what I did was I did cut out the parts where we spent the majority of the time just listening to jury instructions, because sometimes it went over an hour, sometimes it was a little bit under an hour. But I did want to be upfront about that because she was listing off names of victims. I didn't want to come off as disrespectful, but I did just cut those parts out. Okay, I'm trying to be quick because I don't want to hold you all up. I feel like I'm doing a bad job at it though. Before we begin, I do want to say thank you to everybody that donated. Even while I was gone, there were people donating, so I just want to say thank you to everybody. So thank you so much to John Moore for a $5 donation. I really appreciate it, and thank you so much for continuing to watch along and for sticking with me. And thank you so much to Rhonda Kondo for a $5 donation. I really appreciate it, and thank you for continuing to watch along and for sticking with me. Thank you so much to Vicky Bramlett for a $25 donation. I really appreciate it, and thank you so much for continuing to watch along and for sticking with me. And also thank you all for the kind messages as well. I notice I don't say that enough because I do read the comments you guys leave with these messages, so I want to say thank you for all the encouragement and all the support you guys always show. And I do want to chuck this one in because I feel like I've somehow forgot to say thank you to this person, but thank you so much to Rebecca Holexa for a $20 Cash App donation, and I'm pretty sure you sent more than one, but I wasn't sure if I said that in the last videos. But just so you know, thank you so much for continuing to watch along, for sticking with me, and thank you for all the encouragement. Like, I really appreciate it. Thank you so much to Uncle Naldo 80 for a $25 Buy Me a Coffee donation. I really appreciate it, and thank you so much for continuing to watch along and for sticking with me as well. Thank you so much to Faye for a $5 Buy Me a Coffee donation. I really appreciate it, and thank you for continuing to watch along and for sticking with me. Thank you so much to Debbie Lumbley for a $5 Buy Me a Coffee donation. I really appreciate it, and thank you so much for continuing to watch along and for sticking with me. Last but not least, thank you so much to Ty Tyler for a $35 Buy Me a Coffee donation. And it was actually 3 separate donations, but I just put them all together. But I wanted to let you know, thank you so much for continuing to watch along and for sticking with me, and thank you for the encouragement as well, because this time it actually popped up on my phone and I read everything you said, and I immediately jumped up and started recording. But most importantly, I want to say nobody has to send me a single thing. What I do want to say is, if you would like to donate to the community of Waukesha and the victims, there are links pinned at the top of the comment section. So if you would like to donate to the actual victims and the community, there are resources down there for you to do that. Okay, hopefully that was a quick intro. I'll probably put a timestamp somewhere so you guys can jump to the end of this intro, because I got a feeling it's gonna be bad. But either way, thank you to every single person that watches. I want to say God bless you all. I love you so much, and I hope you enjoy the video. Oh boy, here we go. He's back on the screen. The one person I'm least happy to see on my return. You know what's crazy is that right here he doesn't look all that scary. Like, if that makes sense, it's like he just looks like a guy that's wearing a shirt that's way too big. But it's not like somebody you should be necessarily like afraid of. I think they're actually talking right now, but I can't hear anything. In case you all can't hear it either, like, I don't hear it as well. Let me see.
And my 14th Amendment due process rights. I make a reservation for those rights, especially, but all rights at this time.
The record should reflect that the individual known to this court as Darrell Brooks is present in person in custody. He is appearing today in street clothes. He has a dress shirt and a tie on. He's also wearing a mask.
And I don't consent to being called that name for the record. As this paperwork I accept for value and return for value, as it does not state the correct name. It states the name of my client, the straw man. I am not this name in all capital letters. I do not identify by that name, nor do I know that individual.
He's still doing the capital letters thing.
Faceless in law and fact, and that is simply a caption on a pleading
That is not my name.
Final jury instructions.
That is not my name, for the record.
All right, the record should reflect, Mr. Brooks, I'm talking. The record should reflect that at 3:23 p.m. yesterday, all of the verdict forms were printed off and provided to Mr. Brooks. I also provided him with an excerpt from the bench book on closing arguments. I left a copy on the state's table as well, and a second copy on the defense table today as well, so that I thought that would be helpful information as we are about that time in the proceeding for the parties to give their closing arguments. Of course, prior to that, the court
almost
will be
time.
reading through the final jury instructions. The parties were also given the updated version following the jury instruction conference yesterday as well. The total number of pages for that is 107. The court will be reading from the first 73 pages this morning. I do anticipate having to take one or two breaks before I complete all of that. My plan is to do that and then take the lunch break. And then when we come back from lunch, to have the parties provide their closing arguments. And then following the closing arguments, the court has the final jury instructions, which go through the closing instruction, instructions 460, 484, and all of the verdicts, and then the instruction to the jury 515 about their verdicts needing to be unanimous, and then selection of a presiding juror. The very last page, 107, actually is not read until the close of the case and only following receipt of verdicts or some other type of disposition that would result in the conclusion of the case. It's the instruction after the verdict is received. So page 107 is not something that will be read today. As indicated yesterday, I will be selecting the alternates by random selection. We'll use the tumbler and select 3 numbers out of that, but that will be done after all of the instructions are read and the parties have an opportunity to give their closing arguments.
Okay, but as we know, unfortunately, we are not going to get through all 73 of those pages. I mean, we might. Oh my goodness, I just saw the time for this day. 11 hours. 11 hours. That's not even, it's almost 12 hours. So I'm pretty sure a lot of that was due to Darrell constantly interrupting. So I was just about to pause to say that we'll be lucky if we get through like 15 of them, because he's already locked and loaded with some random thing that he's going to scream. As soon as she stops to just inhale, he's going to scream out something. I'm pretty sure right now, after I unpause this, he's going to scream something.
Your Honor, I accept for value and return for value any documents that you just alluded to. I have not seen them.
Alluded to.
Mr. Brooks, if you haven't seen them, that is by your choice. They were provided to you. I know on multiple occasions yesterday you threw items into the garbage can. The court retrieved the final jury instructions. I personally didn't. I had someone do it, had them placed on the table this morning, and any other items you threw in the garbage.
So is that the paperwork that I had to stay here for over an hour for?
Sir,
cares
I'm not
you had
going
to stay for an hour?
further what we did during the jury instruction conference. The jury's going to be brought
Jury
out a
instruction
little
conference.
bit later.
There's a conference. We talking about the proceedings from yesterday, or after you had told us we recessed
Mr.
for
Brooks?
I'm referring to after you called recess for the night yesterday. That's what I'm referring to. I was put in the holding cell for over an hour because they said it was some paperwork that needed to be.
That is correct, sir. You were kept there in order for my clerk, who had to finalize 76 verdicts, 2 each, 1 not guilty, 1 guilty, and provide those to the parties. That's why you were kept there, so those could be handed to you. My understanding is they were. I would need a bailiff to confirm for me whether he took those back to his cell or if they were put on his desk because he left them.
Okay, I'm sorry I'm pausing so early. All this stuff is starting to come back to me because I've been gone for a little while. Okay, so now I'm just now remembering all of the different little games that he plays. So even now, like she's saying, I'll have to bring in a bailiff to confirm. It's like so many things he does just to slow this entire process down, just to have like I guess one more day where he's not considered guilty. Like, I don't even know what his reason is for trying to slow it down, because he's going to spend the remainder of his life in a cage. So I don't understand that part, but yeah, there's many things about him
In the holding cell.
I don't understand.
Left him in what holding cell? In here?
I have to look through his paperwork to see if they're on here.
What holding cell are you referring to, Your Honor?
Behind the door.
No, he
I
forgot.
didn't leave anything in that holding cell. I was just trying to figure out why I was in there so long.
Are those the verdicts?
Yeah.
All right, he has those. Thank you.
Is this the paperwork that was just put on my? It was paperwork on the desk when I came in. That was on top of my folders.
What?
Mr. Brooks, I know that you were given the opportunity to take them to your cell because that is what I was advised. Whether you did that or not, I don't know.
That's
but they
not
are also on your desk now.
I accept for value, in return for value, any documents.
We did discuss all of the jury instructions and the verdicts yesterday.
So what was discussed when I was in the cell for over an hour?
There was no discussion, sir. The court was in recess. Madam Clerk was simply finalizing the paperwork based upon the discussion that was held on the record in open court yesterday.
I was told that I had to stay there per you.
Yes, so that we could provide them to you and you would have an opportunity to take them back to your cell.
But
should
can
you wish
they
to
have
review
been
them.
delivered to the jail?
All right. I don't believe there's
Who
any
cares
other
that you were
preliminary
inconvenienced? That's
issues
great.
we
There are.
need to address other than an advisement I will have for Mr. Brooks. But let me turn to the parties and ask if there's anything preliminary to this phase of the trial, which is the jury instructions, the verdicts, and closing arguments from the state.
No, Your Honor, thank you.
All right. Anything else from you, sir?
Yes, there is.
Of course.
Yesterday, I stressed to the court numerous times about me not understanding the proceedings, and essentially how decisions are being made on my behalf without my understanding or giving consent.
The court made various rulings yesterday. I made findings and ultimately made some determinations. I stand behind the record that was made. I'm not going to explain it further.
So a lot of those decisions were made when I was not present in the courtroom. I was in the other courtroom, correct?
That is true, sir.
Is that correct?
The record will indicate when those were made and where you were.
I can't see the record though. How am I supposed to know what the record will reflect?
It doesn't matter what you see. I don't know why am I actually responding to this stuff? I can tell I can tell it's been a while. No one cares what you understand at this point. That's really all it boils down to when it comes to what I was about to say. Because as long as the record just reflects that you were being erratic and you were throwing paperwork in the trash. I mean, all of this stuff is on video. We're watching you do it right now. So it's just insane that he's playing this game as if he doesn't understand, we don't see it. It's like, it's just, okay, all right.
Sir, the decisions were made yesterday. I'm not revisiting them today.
They need to be revisited, and it also needs to be talked about. Subject matter jurisdiction that has yet to be proven for the record.
Oh boy.
I'm still trying to understand, Your Honor, how you made a judicial determination on my behalf, which I did not give consent to, as you say, I forfeited my right to testify, which I never did. I never said I wanted to. I never said I didn't want to. But that decision was made for me. Also, the decision for the defense to rest its case was made for me, which I did not consent to, nor did I say I was ready to rest, or nor did I say I was ready to rest. I'm trying to understand how all these decisions are being made without my consent, without me waiving any rights.
My goodness, can we throw him in the other?
I'm not understanding how, because none of my answers were unresponsive. I just didn't answer the way that Your Honor wanted me to answer. But I stressed yesterday, if I don't understand something, how am I supposed to answer a question that I don't understand fundamentally? It's not me saying yes or no, and it's not me saying, okay, I want to waive this or that right. And I'm not trying to make an argument with you in any way. I'm just seeking to understand how these decisions are made. If I'm letting the court know and I'm putting the court on notice, hey, I don't understand this or I don't understand that.
Any other things? Otherwise, I'm prepared to address each one of those.
Yeah. There was a mention of if there is a conviction in this matter, there is a mention of sentencing, which I'm assuming there'll be some type of people may want to speak. I know if there is a conviction on my half, people would definitely want to address the court. There'll be a lot of affairs that need to be put in order, obviously on my side. If it pleases the court, if there is a conviction in this matter, I would like the sentencing to not be so quick. I'm asking if it pleases the court for the sentencing to be held off into a later time, not.
This is insane. He has caused 14 days of chaos. And now he's asking the judge for a solid to not, can you please not sentence me too quickly? Can we not throw me in the jail? What's the hurry? You know, why are you guys so quick to throw me in there? Don't you enjoy your time with me? He drove through a parade, and he doesn't want to be thrown in prison too quickly.
A day or two or a week, just so that affairs can be put in order properly, and so that the people that want to come in and speak will have the opportunity to address the court.
I think that's a fair request, sir.
If that pleases.
I think that's a fair request. I thought about that and some more overnight, that in the event there is a conviction, that I would like to give the parties an opportunity to do that. I have no idea how many people would want to speak. My inclination would be, again, and this is not set in stone, if there is a conviction on any of these counts, I may ask the parties to just come back in on Monday, October 31st with kind of a proposed plan of how many people do you think will speak on your behalf, how long do you think it will take, so that I can look at my calendar and then set aside the appropriate amount of time. I certainly don't want to rush anything, and I think that's a fair request that you're making.
Thank you.
I hope it's Rush. I definitely hope so.
So with all of that then, sir, subject matter jurisdiction, I decline to address that further. I stand by the written decision that I've made previously. As far as the rulings made yesterday regarding your ability or inability to present further testimony and witnesses and to testify yourself, the court did make various rulings and findings that you had forfeited your right to do so by conduct. I'm not going to further explain the law or these prior rulings to you. I stand behind them, and I believe I made a very, very clear record. So to the extent that you are asking me to reconsider any of that, that's how I would interpret your statements here today. I decline to do so.
So, Your Honor, would that be...
Of course.
That's still not... I have no understanding to why I wasn't given the opportunity to place certain things into evidence. I have virtually nothing, zero evidence that I was able to place into evidence. Nothing.
I disagree with that, sir. You called, I think, 9 witnesses on your behalf on various issues, including the honking of the horn, the window tinting. You cross-examined many of the state's witnesses about police barricades and the presence of police. So you did present evidence.
I'm speaking to the terms of everything that Your Honor asked me to do. You told me to put everything that I needed to present to the courts in writing. You made that ruling. You told me that's what I needed to do. I did that.
Mr. Brooks, you may have interpreted that. I did not require you to do that. As far as evidence in the case, I very expressly told you there are rules of procedure and rules of evidence that govern exhibits, testimony, witnesses, etc. What I told you is that any requests that you have related to the case, if it's a motion, be put in writing. I specifically referenced the statute 80201 regarding how a motion is made and what it should contain, meaning it has a very express request for relief and states the law and the facts upon which the request is being made. Again, I'm not going to revisit the prior rulings. I stand behind them, and to the extent that the record does not have, meaning the record before the jury and the evidence does not have certain pieces of information, evidence, or testimony that you wanted to present, you forfeited that opportunity yesterday based upon your conduct.
How did I forfeit the opportunity?
Again, I'm not going to revisit that, sir. What I will tell you is this.
How did I forfeit the opportunity? This jury is here
to
be able to place into evidence.
Mr. Brooks, I'm not going to debate this further.
I'm not trying to debate. I'm trying to understand.
To respect the fact that I've made rulings.
Your Honor, you made a judicial determination. It's not my job to explain them to you. I'm not asking you to explain anything.
Then what's the point of you saying right now that you don't understand? One would think that means you want her to break it down to you. But it's like, dude, you brought a picture of your granddaughter and just held it up on live TV, and for some reason he's upset that that wasn't considered evidence. Like, was that a proper process to get evidence into the trial here? Like, none of that, I'm sure, went through the proper channels or anything to actually bring it up, because why would they? First of all, it's absolutely disgusting that he would do that. So I'm pretty sure something like that wouldn't be allowed. I don't even want to think too much into that, because that was insane. And by the way, thank you to everybody that broke that down to me, because I didn't know that was his granddaughter. Like, there was an image of his daughter and his granddaughter, I guess at the time that she was born, which he was using against Erica. It's
misinterpreting what I'm trying to ask you and trying to tell you. You're misinterpreting it. With all due respect, Your Honor. When you tell me this is what you need to do, I'm going to take it by what you're telling me that I need to do. If I needed to make anything request-wise or anything that I needed to present to the court, it has to be in writing. You told me to do that. I did it. You also brought up when I asked numerous times before when would I have a chance to present things into evidence, you told me we were not at the evidentiary phase of the trial yet. So I took that as saying, okay, well, at some point I will have the opportunity to place things into evidence that need to be put in evidence for the record. So I'm not understanding how a decision can be made for me to actually forfeit being able to put things into the record that need to be placed into the record. All these things are things that, quite frankly, allow me to put on a defense. Things that need to be known, things that should be in the record, as far as filings, as far as ICFs that I was told to by you to address certain ICFs either to you or to the clerk of courts, which I did, and received copies for all of them except until last week. It was a few of them that I didn't receive copies for that I'm still wondering why I haven't received those copies when I received the copies of all the ones before that. But in terms of that, I did what Your Honor asked me to do. And these are things that were part of my defense that needed to be placed into the record. So where my confusion comes in is not being able to place those things into the record. Things that clearly help my defense.
I stand by my ruling. I'm not revisiting it. To the extent that you claim lack of understanding or your lack of consent, it's been made abundantly clear on this record your position on that. I'm not revisiting it. I'm further advising you that when this jury comes out, I expect that you will honor the decisions that were made, not agree, but you will honor them and not interrupt the court or these proceedings as I instruct the jury.
So how am I supposed to put these things in the record that need to be in the record?
Mr. Brooks, I'm well aware
It's
of the
over.
effect my ruling had, and I'm not going to debate it with you further.
I just want to know, how am I supposed to get these things on the record? How am I supposed to, because the filings that I gave, you actually filed and gave me the copies back. So are those in the record?
Mr. Brooks, I'm no longer going to talk about this.
I'm just seeking to understand.
Mr. Brooks, I cannot explain procedure or evidence
The filings that
or
I
the
filed.
rulings or
I'm
the
asking
law
a question,
to
Your Honor.
you.
I'm merely asking a question. The filings that I presented to Your Honor.
Any filings
For
with
the
this
court.
court are in the court record. That does not mean they're evidence, sir. And I told you
That's
that
not what I'm
previously.
asking. I'm asking, are the filings part of the record? The filings that were filed and timestamped, that were notarized, that I presented to the court, all the filings, the appearance bonds, the statement of particulars, the notice of special appearance, the court docket sheet, your oath of office, everything that I tried to present into the record. How am I not able to make them part of the record?
Sir, they were filed because you presented them to the court during the course of this case. Anything that was not offered as an exhibit and received during the evidentiary phase is not evidence in this trial.
That's what I attempted to do, and you told me that I couldn't. You told me,
Mr. Brooks, I am bringing this jury
Your Honor,
out.
with
Listen
all
to
respect, you told me that we were not at the evidence. When I said I have exhibits as well, I have stuff that I want to put into the record. I even asked, I said,
Mr. Brooks,
may I give an offer into evidence?
I'm going to stop you
things.
once again. I'm not going to have this discussion and debate. The evidentiary phase of this trial is closed.
It should not be, though, Your Honor.
I understand your lack of consent. Your
So
objection
when would I
is
be able to
noted
put?
for the
When
record.
would I be able to put vital information into the record, which I haven't had the opportunity to do?
That opportunity has closed for you, sir.
So you saying basically you're prejudicing my defense by me not being able to present things into evidence, offer into evidence, filings, and important paperwork and documents.
Mr. Brooks, and you
How am I
forfeited
not-
your right to do that by your conduct yesterday, and I stand behind that decision.
I
I'm going
asked
to do the
before
following,
yesterday,
sir.
Your Honor.
I'm
I
going to
asked
do the
this
following.
before yesterday.
You have not honored my request to you that you cease debating me on prior rulings
I'm not trying
of
to
the
debate.
court.
I'm trying to understand why my due process is being violated.
Mr. Brooks, the
I'm pretty sure he knew when the evidentiary phase was over, because I'm pretty sure when it happened, he threw a tantrum. He wanted to continue to play the games of, oh, my ICFs should be evidence. I learned, well, basically from you all, I learned that sovereign citizens, like a tactic they like to use is to flood the court with a bunch of different documents, and every single one of them have nothing to do with anything at all. So this is all he's doing right now. Now he's trying to act as if those documents would make or break this case. If anything, I guess he's just trying to get off on some sort of technicality, which will never happen. Thank God. Like that's not going to happen. But yeah, he's just trying to muddy the waters here in the hopes that something will come out of this.
The record speaks for itself.
No, the record does not.
I am going to take a 5-minute recess. When I come back out, the jury will also be coming out. I'm advising you there will be no multiple opportunities where I give you to conform your conduct to the rules of decorum and courtesy.
Just hold me in contempt then, Your Honor.
You are
hold
hereby
me in contempt, because I didn't even, I'm trying to seek to understand.
If you start talking about subject matter jurisdiction or any of these other issues,
it needs to be addressed, Your Honor.
In any way,
we're not talking about subject matter jurisdiction. We're talking about why my due process has been violated.
I will excuse the jury and you will be removed to the other courtroom.
We're talking about the 14th Amendment. Section 1.
I'm taking a 5-minute break. We are
Your Honor, I don't agree to a
estoppel.
I don't agree to a estoppel. Your Honor,
I was really hoping she would just remove him right then and there. Let's have another day where he's just in the other courtroom the entire time. But okay, I'll skip over to where to when everybody comes back. So I'll see you all in a second.
Your Honor, it has yet to be proven for the record.
Okay, we're back.
And upon your refusal, that would be looked at as dishonor.
I'm not addressing it. The jury's.
And he's already talking.
So is that a tacit agreement that you don't have to answer any questions as a public servant, Your Honor? Therefore, that's dishonor. Are you going to honor your oath of office?
Stand. I'm not addressing it further.
Are you going to honor your oath of office?
All rise.
So I'll take that as a tacit agreement that you're not going to honor your oath of office.
All right, I'm going to have to excuse the jury.
Oh, wait. He might be getting kicked out here. I mean, he honestly should. He's not going to stop doing this.
Mr. Brooks, I warned you that if you made any interruptions when they came out, you would be removed to the courtroom. That's what I'm doing right now. You're forfeiting your right to be present in this courtroom unless you can promise me right now.
No promises.
Prior rulings of this court and not interrupt this next phase of the trial, which is the court reading the jury instructions without interruption from you. Can you do that?
Have I acted in dishonor, Your Honor?
Mr. Brooks, I very
absolutely
warned you.
Have I acted in dishonor?
You have disobeyed a direct order from this court.
Have I acted in dishonor?
You have disrupted these proceedings.
I have not disrupted these proceedings.
Sir, can you pledge to me that when this jury comes back out, that you will remain silent and not reference things like subject matter jurisdiction, the court's oath of office, tacit agreements, or anything? Can you pledge that you will respect these proceedings and this jury by not interrupting?
Have I acted in dishonor, Your Honor?
I will ask you one more time. Can you pledge to be quiet?
Why does he keep saying this?
Why should I have to make a pledge, Your Honor? Have I acted in dishonor?
Because under Illinois versus Allen, I believe you've already forfeited your right to be here, but you can reclaim that as soon as you are willing to conduct yourself consistently with the decorum and respect inherent in these proceedings, which at this point in the proceedings, sir, all I am doing is reading through the final jury instructions. I do not want that process interrupted by statements by you that are frankly misstatements of the law.
If they're misstatements of the law, Your Honor, how come they haven't been proven for the record? And I'm asking, have I acted in dishonor?
He refuses to answer the questions.
Have I acted in dishonor,
I have given
Your Honor?
him an ample opportunity to do so. He has forfeited his right to be present for the reading of the jury instructions, and he is to be removed to the neighboring courtroom. We will be in recess until that takes place.
Your Honor, have I acted in dishonor?
Why does he keep asking that? Absolutely. You are the You're hands down the most dishonorable person I've ever known. I don't know why he keeps whispering that. I don't know if my volume is too low as well. Let me adjust that.
Everyone, please be seated. The record should reflect that Mr. Brooks has been placed in
All
the
right.
other courtroom. He is presently on mute so that I can make a record. I do need to confirm that the audio and visual equipment and system is working. I am getting a thumbs up from the bailiff. I'll just ask Madam Clerk to confirm with the clerk that's over there as well. I would note Mr. Brooks has the headphones on.
Surprisingly.
This court certainly doesn't take pleasure in removing Mr. Brooks from this courtroom once again. We are at an important stage of this proceeding where the court needs to instruct the jury concerning all of the law that will guide them in their deliberations. As I've put on the record previously, the total pages comes to 107. I will be reading this morning through page 73 prior to the parties given the opportunity to make closing arguments, and then reading from pages 74 to 106 following that. It is very important that the court do this without interruption. Yesterday, this court held a jury instruction conference where both parties had a full and fair opportunity to raise objections regarding any of the proposed jury instructions, to make requests regarding inclusion of any jury instructions that the court did not include, as well as review all of the verdict forms. There's absolutely no reason for there to be an interruption or an objection to this process at this time. The court spent the better part of 25 minutes this morning with Mr. Brooks raising issues and prior rulings that this court has spent an abundant amount of time on, including subject matter jurisdiction. He continues to claim he did not consent. That's been noted for the record. He continues to claim that he has a limited or no understanding of prior rulings and decisions of this court. I repeatedly advised him I would not be revisiting these issues, that I wanted to go forward with the jury instructions, and repeatedly warned him that any interruption once the jury came out would result in his removal from the courtroom. Again, I take no pleasure in doing that. I prefer that he be here, but frankly, the decision I made here today, with the speed at which I made the decision here today, is not only to preserve the dignity of these proceedings, but to do so in a way that avoided the court admonishing Mr. Brooks in front of the jury.
Right.
This, of course, comes on the history in this case with the repeated removals that this court has had to undertake with Mr. Brooks, given his conduct and his behavior in this case. I am currently being advised that he would like to come back. That, of course, is always something that I will give him. As soon as I make my full findings, I will pause, and he will be brought back into this courtroom so that he can be in attendance when the jury is brought out. Of course, my decision that I made this morning to remove him is based on the authority from Illinois versus Allen. I'd also note that State versus Anthony talks about the Allen decision along with State versus Vaughn. Those are two state court decisions. Clearly, even though Mr. Brooks was using a mild-mannered tone of voice, he directly disobeyed the court order that he not interrupt once the jury was brought out. He did that immediately upon the first juror walking in. I believe only a few of the jurors even walked in. He was continuing to talk. I immediately removed them from the courtroom to minimize the impact of his disruption. It was clearly disruptive, but again, he is asking to come back, and I will honor that request. I will further advise him, though, that should he interrupt during the jury instruction phase of this trial by either objecting or raising issues that have no bearing on the advisement to the jury by this court of all of the jury instructions, I will consider admonishing him in the presence of the jury or simply removing the jury so that then I can admonish him and then making the appropriate record. All right, with that, since he's asking to come back, we will take a pause, we'll recess, we'll come back in when he is set up in this courtroom. Thank you, everyone.
All right, we're starting this process. We're getting started already. Him coming in and out of the courtroom. At first, when he was waving his hands, I was thinking that he was gonna work this angle of what does she call it? A jury conference. I was thinking that's what he was gonna try to like argue with her about. I'm pretty sure when she brings him back, he's just gonna do that. Yeah, I'm gonna go ahead and skip over, and I'll see you all in a bit.
Thank you, everyone. Please be seated. I'll have the jury brought out then.
Okay.
Reflect, we are all back in this courtroom.
Before the jury's brought out, can we address subject matter jurisdiction, Your Honor?
I knew it. I knew it.
Absolutely not.
Is that a tacit agreement that you don't have to answer those questions as a public servant, Your Honor? So are you going to act in dishonor?
Mr. Brooks,
Are you going to act in
I've
dishonor?
already addressed your requests.
It hasn't been proven for the record, Your Honor.
The jury is on its way,
They're not out yet, though.
but they're on the way.
You held me in contempt.
I'm not
You held me in
addressing these
contempt
matters,
before-
sir.
Have I acted in dishonor, Your Honor? You held me in contempt without me being in dishonor. How have I dishonored the court? Have I acted in dishonor? Have I rose my voice or argued with Your Honor? Have I disrupted the
Mr.
courtroom
Brooks,
in
you're
any way?
back in this courtroom at your request. The jury is coming
I
up.
never should have
Please
been.
be respectful of their time.
I
and of this
have
process
been. They weren't even
and
out
the dignity
before.
of the proceedings.
They weren't even out before when I was trying to address what needed to be
Mr.
addressed
Brooks,
before they came out.
You're just
Am I
attempting
acting
to
in
disrupt
dishonor?
the proceedings.
Am I acting in dishonor? So that's a tacit
All
agreement
rise
that you
for the
don't.
jury, please.
It's a tacit agreement that you don't have to answer questions as a public servant, right?
All right, the jury.
No
is
jury's
not
out.
Mr. Brooks.
No jury's
close the
out.
door.
I was trying to
Mr.
address.
This is
Brooks, they are
ridiculous.
right outside this door. I am not going to do this with you this morning. You either
I'm not
abide by
doing-
these rules
Am I
and
acting in
stay
dishonor?
quiet,
Am
or
I
you will
acting
be
in
in the other
dishonor?
courtroom.
Am I acting in dishonor?
Yes, you are acting
How?
in dishonor.
How?
Disobeying the
She
direct
answered it.
order of this court to respect the decorum and the dignity of these proceedings. You are merely attempting to delay.
I don't care what you think. That's not accurate.
Mr. Brooks, I am having this jury out.
And-
if you
and you're
say
making-
one word when that door opens,
You're making a tacit agreement.
then you will forfeit your right to be present.
So you're acting in dishonor, then, Your Honor.
All right, the jury may come in.
You're acting in dishonor by making a tacit agreement that you don't have to answer any questions as a public servant. You're not holding up to your oath to protect the
All right, the
Constitution.
door is open and he's talking.
Okay, so you're gonna hold me in
All right,
contempt?
the jury cannot come in. Never mind.
Are you gonna hold
All
me in
right,
contempt?
Mr. Brooks is going to be removed. We're in recess until that
How
can
am
be
I? How am
accomplished.
I acting in dishonor?
Man, that is ridiculous. You can tell he's upsetting Judge Darrell too. Okay, so now he's gonna get put back in the other courtrooms. How many times have I said this now? I'll see you all in a bit.
Thank you, everyone. Please be seated. We are back on. The record appearances are as they were before. The record to
Okay.
reflect that Mr. Brooks is now in the other courtroom. I currently have him muted so that I can add to the record.
Nice.
I have confirmed he can hear and see as well. I would note he does have the headphones on while in that courtroom. He just lifted them up as well, or at least part of them.
He's really
This court
trying to
has
do this
previously
again.
relied upon the U.S. Supreme Court case of Illinois versus Allen, wherein the United States Supreme Court indicated it is essential to the proper administration of criminal justice that dignity, order, and decorum be the hallmarks of all court proceedings in our country. The flagrant disregard in the courtroom of elementary standards of proper conduct should not and cannot be tolerated. We believe trial judges confronted with disruptive, contemptuous, stubbornly defiant defendants must be given sufficient discretion to meet the circumstances of each case. No one formula for maintaining the appropriate courtroom atmosphere will be best in all situations. We think there are at least 3 constitutionally permissible ways for a trial judge to handle such a defendant, including 1, bind and gag him, thereby keeping him present, 2, cite him for contempt, or 3, take him out of the courtroom until he promises to conduct himself properly. I understand Mr. Brooks is waving to the court. I'll address that momentarily. But the bottom line is there is a history of repeated disruptive behavior by Mr. Brooks. I warned him after he came back in. The first thing he wanted to do was address subject matter jurisdiction. That is, from my perspective, simply a tactic on his part to delay these proceedings, to disrupt these proceedings. I've issued a written decision. He has yet to appeal that written decision. He has that right to file an interlocutory appeal. I would also note at no time during this case has jurisdiction ever been challenged when he was represented by an attorney. So I warned him, given the importance of the proceedings and the need for the court to advise this jury without interruption, he was removed once again. I will not bring him back into this courtroom unless he is willing and pledges to conform his conduct and pledge to not interrupt by making any statements when this jury is present and during the court reading all of the jury instructions. I will unmute him so that he can indicate what he would like to say to the court. You are unmuted, sir. Go ahead.
Can y'all hear me?
We can.
First of all, at 9:25, I would like the record to reflect that the prosecution was making dispiriting remarks and gestures in pursuant to what just happened. I don't appreciate it, and I think that that is very disrespectful. For the record. And again, I'm trying to figure out how did I act in dishonor to be removed from the courtroom. How have I acted in dishonor? This is a whole nother. How have I acted in dishonor?
All right, I'm going to mute Mr. Brooks. I'm not going to answer that question. I've made my ruling as far as anything that was done by the prosecution. I was not in the courtroom. The jury was not present. Whatever happened, if anything at all, was done outside the presence of the jury. If there is anything the state wants to put on the record right now, I'll give you that opportunity. Otherwise, I am going to bring the jury out. Mr. Brooks, if you want to come back into this courtroom, you need to write your request down on a piece of paper, and when you do that, pledge to this court that you will not interrupt these proceedings. Without that, I will not bring you back into this courtroom.
Yeah, hopefully he doesn't listen to any of
Anything
that.
the state wants to put on
He should
the
not
record.
come back.
I have a question, Your Honor. I don't have anything directly in response to Mr. Brooks' last statement.
All right, go ahead.
Yesterday afternoon, when we had the 4 screen up, there was a wider view of the courtroom so that the jury box could be seen. Is that possible to do again?
Yes, it is. We can take the witness stand camera and pull it out so that he has a view of the jury box as well. I can't angle it, but I can do that.
And for the record, when you do that, then he can see the jury box. So I would ask that that be done before
Right.
we.
Please do that, Madam Clerk.
I can't court TV see him too, and I thought we weren't supposed to show the jury. That's why I zoomed it back in.
Well,
Unless they turn it on.
it's not on Zoom, and so the court TV would be able to fix the camera on me and not on the screen so that they don't capture any of the jurors, and they're directed to honor that and do that. Same thing, obviously, with our still photographer. If there are any images captured of Mr. Brooks, as you can see the cameras being zoomed out, you would need to avoid capturing members of the jury.
Thank you, Your Honor. The record should reflect you have zoomed out the camera, and it looks
Right.
like about 90% of the jury box can now be seen in the view if Mr. Brooks chooses to do
Right.
that.
Mr. Brooks, I'll unmute. What is it you would like the court to address?
This is going to be something really petty.
how can you rule that I don't have the right to be present in the courtroom?
All right. I've answered that previously. I've made my findings under Illinois versus Allen. He continues to interrupt, even if it is by asking questions. I've made my ruling. The record stands. It speaks for itself. And I intend to have the jury brought out. I need one moment before I do that. And so I'm going to just take about a 2-minute recess.
All right.
All right, we are back on the record. Appearances are as they were before at 9:45. Mr. Brooks sent a note that says, under Illinois v. Allen, I request for the second to be present at my trial. I never consented to not being present, nor did I act in dishonor, because he has not made a pledge to conform his conduct as is required under Illinois versus Allen. He has not reclaimed his right to be present, and
Nice.
we will continue with him in the other room. I will
Great
also
work,
make
Darrell.
a finding today, and I didn't do this previously, although he's forfeited his right to be present, given the technology, the audio and visual equipment that we have, the fact that we've also backed out the one camera so he can see the jurors. I'll make a finding, even without that though, that it's the functional equivalent of being present in this courtroom. All right, with that, then the jury will be brought out. I'll remind Mr. Brooks, while he can reclaim the right to come back into the courtroom and make a request, I am going to be adamant that his request include a statement that he's willing to conduct himself consistently with the decorum and respect inherent in the concept of courts and judicial proceedings, and specifically pledge to not interrupt the reading of the jury instructions. Until such time, he will remain in that courtroom. All right, go ahead.
So yeah, I'm pretty sure that's going to be his main angle for today. I mean, he was doing it last time, wasn't he? Like, it's been a little while now, so like I can't fully remember. But I'm pretty sure he's going to try to do that today, where he's just going to try to use that ability to go in and out of each courtroom to try and slow this down. I mean, there's some reason that this is like a 12-hour day. I mean, they do have a lot of documents to read, so a lot of paperwork, to read, so maybe that's a part of it. But I am like 95% sure that a lot of this is going to be due to him like constantly interrupting, constantly asking to come in and out. All right, the jury's coming out. Sorry if I'm sitting a lot shorter than usual as well. One of the wheels on my chair actually broke right before I started recording, so I just took them all off, so it's like I'm sitting in a desk chair with no wheels. So if it looks strange, I'll see when I edit, but
Thank you,
that's the
everyone.
reason.
Please be seated. Members of the jury, the court will now instruct you upon the principles of law which you are to follow in considering the evidence and in reaching your verdict.
Audio. All right, we're good.
Oh boy, we're back, and you know who else is probably back, right?
All right, we are back
Let's
on
see it.
the record. The jury has not been brought out just yet. I indicated I would address a note that was passed by Mr. Brooks to the court. In it, he indicates the following: I have reclaimed my rights, parenthesis, that I never gave up or consented to give up, parenthesis, to be present, and you have not honored your oath of office to protect my constitutional rights, specifically my 14th Amendment, Section 1, which references equal protection of the laws. Would you like to explain this on the record, or should I will if you won't. I would like to make an offer of proof for my appeal on the record. I indicated previously that should Mr. Brooks want
This is
to
absolutely ridiculous.
come back into this courtroom pursuant to Illinois versus Allen, he could certainly reclaim the right to be present, but he would need to be willing to conduct himself consistently with the decorum and respect inherent in the concept of courts and judicial proceedings. I specifically advise that he would need to pledge to not interrupt the proceedings. He has not done that, meaning he has not indicated he wants to come back or that he will pledge to be courteous and follow the rules of decorum, and specifically pledge to not interrupt as I read through the jury instructions. And his letters or notes that he passed will of course be made part of the record, but I'm going to deny his request to make a further record for appeal, as I need to continue advising the jury of the jury instructions.
I got a feeling she's gonna unmute him.
Mr. Brooks will remain where he is at. Anything further he wants to address, he will need to do that in writing, as he has done with a note, but I don't feel the need to give him any additional opportunity to explain that.
I am so happy. I am so happy she's taking this approach right now. This is honestly the best way to really deal with a man-child like this, is like, because he's using that ability to talk over her and to try to tangle her up in a bunch of words, which he's not even talking about anything of substance. So the fact that he is unable to do that right now takes away his entire, it just takes away his main weapon. I mean, look at how stupid this is right now. He's sitting here waving his hands just to try and get her to unmute him. It's just ridiculous. And the note that he passed, I'm glad that he's like still writing the stupid stuff that he says, and he doesn't have the ability to like cut her off with this nonsense. Instead, we get to hear Judge Darrell read it. Even though it's his words, it just sounds better hearing her read the nonsense, and we don't actually have to hear him scream it at her. And then she just says, yeah, this is worthless. I'm just going to keep going. So, yeah.
What I will ask is he going to make a request to come back into this courtroom? And if that is true, he can give me a thumbs up sign, and then I will address it.
Oh, no.
All right, I will unmute him. Mr. Brooks, what is your request as it relates to coming back into this courtroom?
I've requested to come back into the courtroom with the first writings that you said I had to write.
I put that on the record already, sir. You did not pledge to respect the rules of courtesy and decorum and pledge to not interrupt the court. Are you willing to pledge that at this time?
Your Honor, with all due respect, I've never had to do that before to reclaim my right. I've always asked, when you've given me the opportunity, when I felt that the time was right, I've always asked to come back. Have I not?
Mr. Brooks, given your conduct this morning and your blatant violation of my direct order to you to not interrupt when the jury was being brought out, I felt it important to strictly enforce the language of Illinois versus Allen, and only bring you back if you are willing to conduct yourself consistently with the decorum and respect inherent in the concepts of courts and judicial proceedings, and specifically pledge to not interrupt as I go through all of these jury instructions. If you're willing to do that, I will bring you back in.
Your Honor, with all due respect, can we at least be fair and say today hasn't been as volatile as other days, or as the back and forth between you and I has?
He just acknowledged. I'm pausing a lot more frequently now. I'm a bit rusty with this because I'm just coming back, but it's like he just acknowledged, so he's completely aware of what he's doing here. He just said it's not as volatile as it usually is between us, which is just him that does it. But okay, I'm not going to keep it paused.
Hasn't been what it has been previously.
Mr. Brooks, we started the advisement to the jury an hour later than I anticipated, so I would thoroughly disagree with you that it might not have been volatile or loud.
That's true.
But it was nonetheless disruptive. So, I will ask
Your
you
Honor.
these questions, sir. If you come back into this courtroom, are you willing to honor my request and order to you that you not interrupt as I read through the jury instructions?
Your Honor, I don't understand the question that you're asking.
Sir,
And
are
the
you
reason
willing
why-
to refrain from raising the issue of subject matter jurisdiction if you come back into this courtroom?
Your Honor, with all due respect to your ruling on Illinois versus Allen, that was not part of Illinois versus Allen. I don't understand why that's being
Mr.
made
Brooks, I'm
on-
not going to debate the meaning of Illinois versus Illinois v. Allen with you. I'm simply trying to get you back into this courtroom. You seem to want to be here, but you don't want to pledge to follow the rules of courtesy and decorum. So that's on you.
Your Honor, this is never
Oh
been
my
done
goodness.
before. It's never been done before, and I've always been able to reclaim my right to be able to be present.
Are you willing?
Which is what I stated when I first came over here. I've been stating the same thing. I've actually told the bailiff numerous times.
Mr. Brooks, I am strictly enforcing the language of Illinois versus Allen, which says the following. I will repeat myself again. Once lost, the right to be present can, of course, be reclaimed as soon as the defendant is willing to conduct himself consistently with the decorum and respect inherent in the concept of courts and judicial proceedings. I have not required the pledge previously. I've allowed you to come back, but given the interruptions this morning and your immediate discussion of things like subject matter jurisdiction and my oath the minute one juror walked through that door, I cannot take that. I will not bring you back in without that pledge.
So where does it say anything about a pledge, Your Honor?
Sir, I'm not going to debate the language with you. I am establishing what I believe is a reasonable restriction on your right to come back into this courtroom based upon the history in this case of your repeated violations of the simple rules of courtesy and decorum and your failure to follow my very clear and direct requirement this morning that you not interrupt the reading of the jury instructions and you be silent once the jury entered the courtroom. I did that in part because it not only preserves the dignity and decorum of this trial, it also frankly protects your rights and it minimizes your bad behavior in front of the jury.
Your Honor, now I didn't interrupt you while you were talking.
Oh my goodness.
I let you make your
That's
record
not even the
without
point right
talking
now.
over you or interrupting you.
Thank you. I would agree with you just now.
The way that I'm interpreting, when you reference to me, with the Illinois versus Allen, where your ruling is coming from, the way that I interpret that is not the way that you're saying it to me now. That's why I don't understand what you're asking. I'm interpreting that in a totally different way.
Okay, let's move on
I
then.
refer
He doesn't
you
understand.
to the third section of Illinois versus Allen, where the U.S. Supreme Court was discussing what the trial court did in that case, and it said the following: the trial court in this case decided under the circumstances to remove the defendant from the courtroom and to continue his trial in his absence until and unless he promised to conduct himself in a manner befitting an American courtroom. As we have said earlier, we find nothing unconstitutional about this procedure. So that is the authority, sir, in addition to the other quotation. I'll tell you this. I'll give you one more opportunity, sir. You can come back into this courtroom, but I do not want you to address or attempt to address subject matter jurisdiction or any of the other rulings that I've previously made. I need to continue with the advisement to this jury about the rules that govern their deliberations. That is the stage we are at. And if you violate that in any way by raising any of those legal issues in their presence, that will be in direct violation of the requirement for you to reclaim your right, and you will be removed back to the other courtroom. Did you hear me say that, sir?
I'm informed, but Your Honor, now you just stated on the record if I raise these issues in their presence, but if they're not in the courtroom, it's not in their presence, correct?
Sir, I can't bring them into the courtroom until you're here. I expect you during that short interval not to raise these legal issues that I've already addressed multiple times. So yes, I'm telling you, if you come back into this courtroom, I don't even want to have you raise any of those issues. I want to bring the jury right out without interruption. That is my clear expectation, whether the jury's in the courtroom or not.
Your Honor, I'm confused because you just said don't raise any issues in their presence, and now I'm confused.
Because you're indicating to me by your statement that you intend to raise them once you get back into this courtroom. And so I'm making that another restriction, and you need to pledge to me that you will not do that.
Your Honor, the way that I'm interpreting what you just read to me from the other section that you just read from Illinois v. Allen, it does not have that language. So I'm
Mr. Brooks, I'm not going to debate the language. Do you want to come back in here or not?
I've stated numerous times that I shouldn't even have been brought over here anyway, and that I wanted to come back. But now what I don't understand about it, Your Honor, is that there's being rules enforced.
Mr. Brooks, do you want to come back in here or not? It's a very simple question.
I said yes already.
All right,
how many
then
times
I'm
do I
going
have to say the same thing?
Because then you go on and make other statements, and then I can't even effectuate your request.
But I'm trying to tell you how I'm interpreting what you're saying to me. If you want
Mr. Brooks, I'm going to mute you. We're going to go in recess. He can be brought back over, but I will advise you that if you start back in, even outside the presence of this jury, with any of the legal issues I've already ruled on, you will go back to the other courtroom. It's that simple. So we'll be in recess. He'll be brought back over, and then we'll start back up.
Yeah, I think we know the end result here that's going to come out of this. He's going to come in there and immediately say, I didn't understand any of that you told me. So I'm just going to ask it again. That's exactly what's going to happen. He's going to pretend like he didn't understand it. And he's just going to get kicked out again because it takes up time. So, yeah, Darrell's standing on his last leg here. He has absolutely nothing left. But I'm just going to... Well, I was going to fast forward, but he's being extremely animated. As Looney Tune characters tend to be. Okay, I'm sorry. I'll jump forward. I guess he's just going to wave his arms around, so I might cut forward from this.
Or as they were before, the record to reflect that Mr. Brooks remains in the other courtroom, despite what I thought was, he made clear he wanted to be here. My understanding is he is now saying he doesn't understand what this court wants. I've made it very clear, I believe, what this court's expectation is, that I continue with the jury instructions without interruption, that Mr. Brooks follow the rules of courtesy and decorum. He's had those for quite some time, and that he conduct himself consistently with the dignity and decorum that these proceedings deserve, and that includes not interrupting or bringing up legal matters that this court has previously ruled on. We have lost a significant amount of time now addressing, or not even addressing, but Mr. Brooks really interrupting the flow and the proceedings based upon his responses, and then he attempts to engage with this court on the meaning, for example, of Illinois versus Allen. He needs to make a very clear statement to this court, not an ambiguous one, but a very clear one, that he wants to come back into this courtroom and that he's willing to conduct himself appropriately. And until he does that, he will continue to forfeit his right to be present in this courtroom as I instruct the jury. So with that, I did give him 5 minutes. I said, you have 5 minutes to decide. I set a timer. It went off. He is still in the other courtroom. We are going to continue. So the jury is to be brought out.
Awesome. That is awesome.
Madam Clerk confirmed that the audio and video is working just fine.
I'm glad they caught that before he came back into the main courtroom there. It's nice that we come back and he's
to be muted, so as there are not interruptions. And if he wants to address something with the court, he needs to write it on his pad of paper, and I will address it at the appropriate time.
nice. But yeah, it's pretty clear to the jury too right now that the entire reason they're not here is because of him. I'm sure they're not wondering like, oh, why?
On the record that at 11:01 I took the break. It's now 11:48. So I intended to take 10-15 minutes tops. And Mr. Brooks, you can write it down. I'm not going to interrupt further. The jury's coming out.
All right.
Did the accident
I
involve
hope they get the
death,
camera
pain,
off
or
him
wound?
because
If you are satisfied beyond a reasonable doubt that all four
This
elements
guy,
of
man.
hit and run have been proved as to count 70, you should find the defendant guilty of hit and run as charged in count 70. If you are not so satisfied, you must find the defendant not guilty. If you find the defendant guilty, you must answer the following.
okay, I had to pause right there. This is like every time we get to a point like this where they start actually listing off the victims, because at certain parts you're so focused on dealing with him and how crazy he is like in the courtroom. It's not that like you forget, but then when it's brought back to the forefront, the fact that there are so many victims and they're sitting here reading them off, and I'm getting like angry. And then he just starts waving his hands so he can talk about subject matter jurisdiction. This guy, man, absolute scumbag.
Yes or no. Did the accident involve? At this time, I will reserve the instruction on closing arguments because we are going to take our lunch break and then come back after the lunch hour for closing arguments. All rise for the jury.
All right. So I'm going to skip forward to when we come back from this break as well, unless they talk a little bit, which they might. But, yeah, Darrell was basically using the Bible as a prop again. Surprise, surprise. To wave it back and forth to get her attention. I'm not sure if I included that part, but yeah.
I think you be seated. As soon as the doors close, I just need to put a couple things on the record. As I read, the doors closed, right? There we go. As I read through the bail jumping, it dawned on me that the battery should not be referenced because the battery was not on Main Street. And so I took it out because the way that the charge and the information reads, and we had that discussion preliminarily, which is why later on it doesn't reference the instruction for battery. So I cleaned that up by rereading it and taking that out. So I wanted to make a record of that. Obviously, I will need to have a new set made that has that correction. And I apologize for not catching that previously. But obviously I caught that as I read it. There was one other heading that said preliminary on, I think it was instruction 70. I need to cross that out. And I think I found the word a or depending on how you say it, missing from one thing. I'm going to add that in, and I'll have that for the parties.
Okay, yeah, this is a good reason as to why he's not in here, because if that would have happened in front of him, I could see a moment where he just cuts her off and says, oh, what are you trying to pull? This is proof of bias or something like that. I could see it.
I did note that at approximately 12:19, it may have been a little bit earlier than that, but I noticed Mr. Brooks was waving his hands. At one point I did indicate I would address that at a later point in time. I am aware of a number of filings. I addressed 2 of them previously, but there are 2 additional. I am going to have copies made of all of these filings for the state so that they have an opportunity to review them. From my perspective, just briefly, he is making some objections to what I am doing, but at no time in those did he ask to be brought back to the courtroom, and certainly within those, he did not pledge to follow the basic tenets of courtesy and decorum. Given where I was at in the proceedings with the reading of the preliminary instructions, and given the court's prior finding that he had forfeited his right to be present, I thought it important to get through the reading of the instructions up until the point of the closing argument instruction, which I reserved because I'll review that with the jury when they come back, prior to the parties being given their opportunity to give closing arguments. I will also be advising Mr. Brooks that given that I'm moving on to a second part of this, that being the closing arguments, he will be invited back into the courtroom here for those closing arguments, of course, subject to his conduct. I expect that he will follow the rules of courtesy and decorum, and also not raise legal issues in front of the jury when they are here. With that, we will take our lunch recess. It's 12:47. We'll take an hour and 15 minutes. Thank you, everyone. So yeah, make copies of all of you.
He looks so defeated right there. Really, all that means is that as soon as he comes back in, he's going to act like a whiny brat, because none of the things he tried were working. So now he's just angry about that. So when he comes back in, he's going to act whiny, and he's going to say, no, I'm not going to. You don't care anyway. I'm not going to spit. Like, it's so weird hearing a grown man talk like this. But okay, all right. We're going to go ahead and skip forward. All right, so he's actually back in the courtroom, pretending to read something. I don't know. But while we have some time here, I want to say thank you to everybody that's watching along. And thank you to everybody for just constantly tuning into this stuff, because like all of the comments I see, all of the support all the time on these videos, like I can't explain how much I appreciate it, especially when I take so much time off and then you guys still want to see this. So yeah, I really can't say how much I appreciate that. What is he looking at right there? I'm guessing he's trying to take a look at the people behind him. Like, which is creepy. I have no idea what he's doing. I would say 99% of the things he does creeps me out, though. I just assume it's like something weird. Like he literally could be picking a flower out of the ground and I would be concerned as to what he's doing with that.
All right, it's 2 o'clock. I'll call the case. State of Wisconsin versus Darrell Brooks, case number 21 CF 1848. May I have the appearances, please?
Good afternoon, Judge Sue Arthur, Leslie Daisy, and Zach Wichow will appear for the state.
I'm here without prejudice by special appearance. Beneficiary, I'm here under fraud, menace, duress, and extortion. Judiciary, Jennifer R. Darrell. This is a social security, SESTQ, trust.
What? Okay, so he's completely switched up his intro now. I don't know what he just said. He put her name in it. I'm sorry. I don't usually. I'm going to go back just a little bit. Okay, hold on.
I'm here without prejudice by special appearance. Beneficiary, I'm here under fraud, menace, duress, and extortion. Judiciary, Jennifer R. Darrell. This is a social security, SESTQ, trust action which you are a real party and interest to as sui juris and propria persona. This is a military admiralty tribunal and maritime law under Title 4 of the United States Code Section 1, which you can see.
This is insane. This is okay.
States placing a fringe on the national flag is within discretion of president acting as Commander-in-Chief of the Army and Navy. Is this a common law court or an admiralty court?
The records reflect that the individual known to this court as Darrell Brooks is present in person in custody. He is wearing a dress shirt. I know he has a suit coat, but it's not on. He's also wearing a mask. The court is not going to address any of the issues that he is raising as they are meritless. I would also say the same as to the notes that he passed while he was in the other courtroom. For the record, I did provide a copy of all of those to the state as well. They are also uploaded into the file and are made part of the record. To the extent that he raises objections or lack of consent, it is noted for the record.
I was about to do that and say that I don't consent to being called that name or identity. That is the trust name, and it is not me myself. I don't recognize that name, nor do I consent to being called by that name. With all respect, Your Honor.
That was absolutely ridiculous.
Your subject matter jurisdiction has yet to be proven on the record.
These. No, where is?
May I receive those original copies time-stamped?
Okay. All right, I need to make a record of one part of a jury instruction that I do need to advise the jury. It will also be corrected in the packet. I believe within the last year, the jury instruction on credibility of witnesses was modified by the jury instruction committee, and it was just an oversight on the court's part to not include, it's really just one paragraph. It was read to the jury at the beginning of the case with the preliminary instructions, but it is a paragraph regarding implicit bias, and so I do think it's important to advise the jury of that. I intend to do that when they come out, and then again, the full instruction will be amended so that it's in the packet that goes to the jury. And Madam Clerk, if you haven't already, if you could print off page 72. It's the it adds a paragraph before the last paragraph that starts with, "There is no magic way for you to evaluate the testimony." And again, I wanted to be consistent with the most recent version of the jury instructions and consistent with what was instructed or provided to the jurors at the beginning of the case. And so I will make sure that they have that, and so advise them when they come out. Also, I will read instruction 160, closing arguments. Madam Clerk, if you could just make the change so that it's of parties. We've missed that correction as well. So it's the closing arguments of the parties, not the attorneys. And so I will just make that correction and make sure it's...
I accept for value and return for value this document, and Your Honor, I requested that I have copies of my filings from earlier, time-stamped.
Mr. Brooks, I'll provide you with the copies later on. I need to continue with the instructing of the jury and have the parties make their closing arguments.
Your Honor, with all respect, the state received copies. How come I can't receive the copies of my filings?
You know what? I can give you the print-offs, but I can't give you the originals right now. That's what I'm referring to, and you will absolutely get those back. I guess I was mistaken that you wrote copy on it. I thought you retained a copy for your records. So with that, Madam Clerk will print off from the record. It won't be the yellow copies just yet. I'll take that up later outside the presence of the jury.
He's not going to accept that.
Given to them. Now, in terms of the closing arguments, I did set a time limit for the parties yesterday. Each side will have a total of 1 hour. Mr. Brooks, so that you are fully aware, the party with the burden of proof, which is the state of Wisconsin, goes first. Then you, as the opposing party, will have an opportunity to respond and argue. And then, time limit willing, the state also has the opportunity to present rebuttal because they have the burden of proof. And that is provided with the excerpt from the bench book that was provided to you yesterday. It has the purpose of the closing arguments is to summarize the facts, marshal arguments, focus the issues for the jury. I just talked about the order of the arguments. The scope of the arguments, are the content, duration, and form of argument are within the court's discretion. That's why I set a time limit of 1 hour for the parties. And Mr. Brooks, I will advise you that I certainly will wait and see how you present your argument today. I will certainly wait to see if there are any objections raised, but I also want you to be aware that if I feel the arguments are improper, I may simply, without an objection, say, please move on, as a clear indication from this court that what you are stating is not proper under the various rules and case law that govern closing arguments.
He's definitely going to do that.
No prejudice. I'm here by special appearance. I don't consent to being called that name for the record.
It's noted, sir. All right. Then with that, I will have the jury. Oh, go ahead. Looks like Attorney Opper has some issues she wants to raise.
Yes, I just have one question, Your Honor. Would I have permission to put the easel up and display some of the poster boards? I did confer with Captain Dussault as far as security is concerned, and he agreed to it if the court would give me that authority.
Where would it be displayed?
He's going to put it like right here, and then you want me standing at this table during
I do.
Yes, so I would just position it like right here. And I don't have to leave it up through the whole thing. I realize it blocks the view of people in the courtroom. Detective Casey would be willing to assist me in removing them when I'm done with them, if that's okay with you.
I trust it won't block Mr. Brooks' view of the jury, and
That's
as long
what
as
I was going to put it like right about here so that he could still see me and the jury.
with that caveat, yes, I will allow that.
All right.
Objection. What is that? What is supposed to be put up?
They were previously admitted, Your Honor. It's Exhibit 15 and 130, I believe.
So are they exhibits? I'm confused to what they are.
Mr. Brooks, I've made a ruling. The state has made a request. I've granted it.
She
Yes,
just
but
called it
in terms of-
exhibit.
I don't understand what's being shown. Should not have the right to ask, to object and ask what it is that's actually going to be shown.
The state's put on the record what it is. They are exhibits that have previously been received by the court during the course of this trial. That is proper for a party to do that during its closing arguments.
So can I put up exhibits?
That's a good joke. You have no exhibits.
I don't know what you have planned for your closing argument.
I'm making a request, the same request. May I be able to put up
Well, I
exhibits?
guess it depends on what it is, sir. So I'm not going to take up any more time because what I intend to do is once the state goes through its closing, I may take just a short comfort break depending on how long it is. And if there's something in particular, you will need to tell me what it is. As long as it's an exhibit from this case, then I wouldn't have an issue with it.
They would be from this case, obviously. It's just not nothing that the state has.
Then it's not.
I'm not aware of exhibits that the state wouldn't have, that you would have. Everything that's been received, we have a list. So if it's not something that was received during this trial as an exhibit by the court, unless you tell me what it is so that I can make a ruling.
Okay, sorry to pause in the middle of that, but it's insane how he thinks this works. And look, I'm not entirely sure if this is true or not. Like, it's just something that I feel like I figured out from looking at other trials. But he believes that you're able to surprise the prosecution and like you can just produce certain information that they don't know about. When I'm pretty sure in a trial, all the evidence has to be provided and all the exhibits have to be provided up front. So we all have the same exhibits, but as far as like your argument, I guess that part is up to you, but you can't surprise people with an exhibit. Like, I don't know. And I'm not even gonna lie, like I actually thought that it kind of worked that way too until I started watching some of this kind of stuff, and then I realized like, okay, I'm pretty sure you can't do that now. But
I can't see how it would be relevant or appropriate for your.
let me know if that's true or not.
They're part of my filings that you filed.
The filings have no relevance to the issues that are before the jury. The closing arguments are to direct the jury so that they have your arguments so that when they go back to determine the issues in this case, which are related to whether you're guilty or not guilty of the 76 charges. Things like subject matter jurisdiction or like that would not be something that would be proper before this jury. Those are legal issues that the court would decide. The jury is the judge of the facts. The court is the judge of the law. That's why I have all of these jury instructions to give to the jury.
I'm not referring to subject matter jurisdiction.
What are you referring to then? Be very specific so I can make a finding and ruling.
I was specific, my other filings that
That's
was
not
filed.
specific enough, sir. What are you
My
referring
court
to?
docket
Which
sheet,
filing?
let me know when you're done, Your Honor.
Which filing, sir? Not generally, but specifically.
Absolute child.
Are you done?
Can we move on? Please move on now.
Are you done?
Sir, that's very rude and
No,
disrespectful.
I didn't know if you was finna say something.
I
That's why I'm
paused.
asking, are you done?
What filing
Your Honor,
are
how
you
come
referring
every
to?
time I try, even when I try to err on the side of caution, you find some way to make it to be something that it's not? I didn't know if you was gonna say something else.
I've asked a question, sir, so when I do that, I would hope it would convey to you I'm looking for an answer. So which filing are you referring to?
All
With
my
specificity.
filings, my notice of appearance, my statement of particulars, my bond, the court docket sheet, all of those filings.
The request to display those to the jury is denied. It's not relevant.
How is it not relevant? Not even your
That's my
oath of office?
determination, sir, so I am going to start this.
Not even your oath of office can be shown?
No, that is not relevant to these proceedings, sir.
It is.
It's not relevant in front of the jury.
Why is it not relevant? Can you
She's not on trial. What is the...
You
explain
are
why
So
not
it's not
going
strange.
to be
relevant?
able to raise those types of issues and present a closing argument based upon my oath of office, whether I'm licensed to practice law in the state of Wisconsin.
I said your oath
whether
of
there's
office.
subject
I didn't
matter
say anything.
jurisdiction, whether you consent to this appearance or not. None of those things help the jury determine the issues in this case, which are related to whether you are guilty or not guilty of the 76 charges that have
The
been
jury
filed
should
in
know
this
that
case.
they should know the truth in their duties, in their rights. They should know that at least.
Mr. Brooks, I'm putting you on notice that if you continue with this insistence upon presenting information that's not properly before the jury as evidence in this case, that I will instruct you during your closing argument to move on and potentially ask the jury, have the jury leave so that I can admonish you. And if you keep insisting on that, sir, that will be in direct violation of the court's direction to
So
you.
they can't even know that I got a shock device on my ankles?
They absolutely do not need to know that.
Why
So it's
not?
not relevant to the determinations of guilt or innocence in this
It's
case.
the truth.
Mr. Brooks, your custodial status is not on trial here.
I will argue that it
Your
is.
conduct from November 21st of 2021 is what
That
is
hasn't
on
been
trial.
proven.
You may not bring up the way that you've been shackled. It's not relevant, sir.
It's
and if
the
you
truth.
do so, you do it at your peril. But here's the
There
thing:
is
the
no
jury
peril.
is specifically.
It's my right,
no,
though.
Let me go. Okay.
It's my constitutional
is-
right. Just
There
like
are
under the
certain
First
things
Amendment,
that
which I
you're-
preserved my First Amendment right when I came in this morning, I also preserved my
All right,
Sixth
Mr. Brooks,
Amendment right.
Please stop. You do not have an unfettered First Amendment right. That is very clear based upon
What do you
all
mean
the
by
case law.
unfettered? What do you mean by unfettered?
It
I
means
don't.
it is not absolute. It can be restricted.
So the Constitution of the United States can be constricted.
All right, Mr. Brooks, I'm putting you on notice that if you continue with your insistence on raising issues that are
I'm going to
merely a
raise issues that the
distraction,
jury needs
that
to
are-
know,
They're not
regardless,
issues.
because they're under the rights of the United States Constitution, which
Mr.
is the
Brooks,
law
I
of the
direct
land.
your attention to closing instruction 460,
I'm
which will be
going
read
to
jury
let the
at some
jury
point.
know the truth, their duty and their rights. Under the First Amendment and under the Sixth Amendment, I have the right to inform them of their rights, of the truth, and of their duties. Under the First Amendment and under the Sixth Amendment of the Constitution of these United States.
What exactly do shackles have to do with any of that? Even what he's saying right now, his shackles or shock shackles or whatever he called them, has nothing to do with any of that stuff. Him informing them of what their rights are. I'm not even... Okay, let me not try and even make sense of this.
No state law can override that.
Mr.
Any
Brooks,
law,
do you intend
any
to
law
keep this up when the
repugnant.
jury comes out?
Your Honor.
Because I need to
No, I
have
do
the
not. That's
state-
why I'm addressing this before
not-
before they come out. That's why I'm trying to address this before they come out, so it doesn't become an issue once they're in here. But under the First Amendment and under the Sixth Amendment of the Constitution, which are rights that I preserved the moment we stepped in here this morning when this proceedings started, I preserved those rights for the record. And now you're telling me that those rights are not, would you say unfettered or, I don't know what you say. I don't even know what that means. I don't even understand that. But any law repugnant to the United States Constitution is null and void.
Mr. Brooks, I'm putting you on notice that you can also forfeit by your conduct the right to present a closing argument. In appropriate circumstances, the right to present a closing argument, no different than the right to testify, may be subject to forfeiture where your conduct is incompatible with the assertion of the right at issue. The goals that this court has attempted to follow throughout this proceeding are multifaceted and multifold. Number one, I do have an obligation and I have done my best to ensure that this is a fair trial. However, a fair trial does not mean a defendant has unfettered rights to state whatever he wants when he wants. This court, not only through the course of the trial, is deemed with the responsibility to control the presentation of evidence so as to ensure fairness and reliability of the criminal trial process. It also includes ensuring that the closing arguments are relevant, are appropriate. This court must also be concerned with efficiency and effectiveness, and of course, last but not least, courtesy and decorum in this courtroom, what I would generally refer to as civility in the courtroom. You do not have unfettered First Amendment rights or an unfettered Sixth Amendment right, sir. You must conform your conduct to the rules of decorum, the rules of evidence, and the rules of procedure. While you have a right to present relevant and probative arguments to this jury, you may not present arguments related to such things as jury nullification, subject matter jurisdiction, the court's oath or lack thereof, if that's what you believe, whether this court is a court of common law, admiralty. All of those things relate to your claim as being a sovereign, which are frankly baseless. They're meritless. They've been debunked by many courts, including the court in the Beneby decision that's been referenced by this court previously. I will give you a fair opportunity to present a closing argument, but again, it is not unfettered. The simple fact is, sir, this court can restrict your right to present a closing argument. This court has the authority under 906.11, under the various cases, including Illinois versus Allen, including Rock versus Arkansas, although Rock versus Arkansas and Chambers versus Mississippi dealt with the right to testify. There is a decision, I looked it up earlier, and I'll just pull it up and tell you the case site so that you have it. I would direct your attention to Herring versus New York, found at 422 U.S. 853, a 1975 case, although in a footnote, it does stand for the proposition that a defendant who has exercised the right to conduct his own defense has, of course, the same right to make a closing argument. That's quoting State Ferretta versus California, or following the same logic from Rock and Anthony and Chambers, a right, even a constitutional right that a defendant has may be forfeited by conduct. This court just like it attempted to do with regard to your right to testify and set up reasonable restrictions so as to meet all of the goals that the court needs to meet, will be as follows, and that is, again, sir, you may not bring up matters that are not relevant to the determination of guilt or innocence. That means evidence that was not presented and not received in this courtroom is not relevant to your closing arguments. It's not, the arguments must be based on the law, not as you interpret the law, but as the law is. You must base your closing arguments on the facts that have been established during this case, meaning the evidence, the testimony. As I indicated earlier, the purpose of a closing argument is to summarize the facts, marshal arguments, and focus the issues for the jury. It is fair that you comment on evidence, including arguing evidence to the conclusion or inference. It is your ability or your opportunity to convince the jury that you are not guilty of these offenses. You may not convey any idea that you have undisclosed information. Neither party may vouch for a witness or otherwise express personal belief or opinion regarding truth or falsity of any testimony or evidence. It would be improper to ask a jury to draw inferences that the parties know are not true. And your comments on evidence is limited to evidence in the case. You may not comment on facts outside the record or peculiarly within your own knowledge. And that is just some of the guidelines for determining the proprietary of arguments that I am guided by from my judicial bench book and all of the cases that are referenced therein. So you are put on notice, sir, that even without an objection, this court may, in an effort to preserve the dignity, the decorum, and to keep the issues properly before the jury, may advise you during your closing argument to move on. If you do not honor the court's rulings, then you will run the risk of forfeiting your right to be present and potentially forfeiting your right to further present your closing argument. With that, I am bringing this jury out to complete the instructions that I need to complete, to add to the credibility instruction the paragraph on implicit bias, and to let them know the full instructions that they receive will have it, to read 160 closing arguments of the parties, and then to have the state go first as they bear the burden of proof.
Now you're
Okay, he already started talking right there. I was just about to say, I hope that he just keeps arguing right now, because I have a feeling it's going to result in him not being able to give a closing argument. Like, I'm pretty sure he's just going to keep ramping this up, because you can feel it. Like, you can feel that this is building up to something. He's eventually just going to start screaming, I'm pretty sure. So I hope he does keep going, and then just no closing argument.
Your Honor, I just let you make your record. I didn't overtalk you. I didn't interrupt you. Is that fair to say? I let you make the record. With all due respect, when will I be able to make the record? As I've tried to do numerous times by saying I wanted to present an offer of proof for my appeal. That's the chance for me to be able to make the record.
I'm denying your request to make an offer of proof regarding your appeal. I am
not
not
allowed to
required
make
to
the
give you
record
that
at all, Your
opportunity,
Honor?
sir.
I'm not allowed
Sir,
to make the record at all, as I just let you did, because some of the
Sir,
issues
I
has
have-
been some
you
of the
have
issues
told me
has
what
been
you want to do. I've
Your
told
Honor.
you you can't. I've addressed
Your
the
Honor,
request.
some of the issues have been me over talking you and interrupting you. I did not do that.
You literally just did.
Even though everything that you said, you have not proven for the record, and it's unlawful law. You haven't shown one time that is lawful for you to do what you been doing as
Mr.
far
Brooks,
as your rulings.
once again, I'm not going to debate with you the prior rulings of this court. There is absolutely no need at this point for you to make an offer of proof regarding my prior rulings or decisions that you disagree with.
Your Honor,
you will have an opportunity, if convicted, to raise every issue.
Contempt. Hold me in contempt.
Wait, what just happened?
I have constitutional rights that are being trampled on, and you're coming up with ways to.
Okay, I'm sorry. It jump cut or something. I might have to find another video.
You will have an opportunity, if convicted, to raise every issue.
Contempt. Hold me in contempt.
Okay, so apparently Judge Darrell just walked off. I have no idea what happened. I'm gonna see if I can find another video though. I'll be right back. Okay, so I found another video. Hopefully it shows everything that happened. It kind of jump cut at the end there, so we're gonna see what happened, but okay.
I'm not allowed to make the record at all, Your Honor.
Sir.
I'm not allowed to make the record at all. As I just let you did, because some of the issues
told me what you want to do. I told you you can't. I've addressed the request.
Some of the issues has been me over talking you and interrupting you. I did not do that. Even though everything that you said, you have not proven for the record, and it's unlawful law. You haven't shown one time that is lawful for you to do what you've been doing.
Mr.
As far
Brooks,
as your ruling.
Once again, I'm not going to debate with you the prior rulings of this court. There's absolutely no need at this point for you to make an offer of proof regarding my prior rulings or decisions that you disagree with.
Your Honor,
you will have an opportunity, if convicted, to raise every issue you want on appeal.
I'm going to inform the jury of the truth, their duties, and their rights, as I have the right to do under the First Amendment and under the Sixth Amendment. You can't disregard the United States Constitution. You can't do that. Again, any law repugnant of the United States Constitution is null and void. There's no state law that you can cite. There's no federal law that you can cite that overrides the United States Constitution. You know
Brooks,
this.
I direct your attention to State versus Anthony. Although that case dealt with the right to testify.
Okay, so we're not talking about the right to testify. We're talking about the closing arguments, correct? We're not talking about testifying, which you already made a ruling on.
I'm not going to delay.
You already made a ruling on.
Arguments
but
of
Your
the
Honor,
parties.
with all due respect,
I will address your further request.
With all due respect, you already made a ruling about testifying. Did you or did you not?
Mr. Brooks.
So we're talking about now. We're talking about closing arguments that I said it's my right to be able to inform the jury of the truth, their duties, and their rights. That is my constitutional right.
Mr. Brooks,
you
we
can't
are at the
tell
stage
me
of the
I
proceedings
can't.
where it is the state's burden of proof where they get to make their closing arguments.
We're talking
first.
about me, though.
I understand that, sir, but
I'm going to inform them of the truth.
Right now is delaying.
I'm not intended
the court's
to delay anything. I'll let you, Your Honor. I just sat there and let you make the record. I didn't overtalk you or interrupt you. I let you say what you wanted to say. I let you make the record. I didn't interrupt you not one time.
No, but sir, you're attempting to disrupt the proceedings by going off on a tangent into all of these other issues. From my perspective, that is in an
how am I being
attempt to
dishonored?
simply
How am I being
delay
in
what we're
dishonor?
doing.
How am I being
you are
in
put
dishonor?
on notice. I am
Literally at this moment.
How am I being in dishonor, Your Honor? How am I being in dishonor of the court?
Mr. Brooks, I've made my determination.
And have I not preserved my right?
This further.
Have I not preserved my right?
If you insist on interrupting the court and disrupting the flow of these proceedings,
please kick him out.
By a blatant disregard for the parameters that I've set up, you will forfeit your right to be present in this courtroom and potentially forfeit your right to present a closing argument.
Under what law can you do that?
Sir, I've
made
my determination.
You can hold me in contempt by Illinois versus Allen. You can do that. You stated that numerous times.
Mr. Brooks, I want you here for the closing arguments.
Apparently
but
you don't.
Apparently
you don't, Your Honor, because all I said was it is my right under the First Amendment and the Sixth Amendment to inform the jury of the truth, their rights, and their duties. I never once said anything about, I'm going to bring up subject matter, or I'm going to bring up this,
sir.
or I'm going to bring up that.
See what you have to say, but I thought it prudent, given your conduct to date and your insistence on bringing up issues that have no bearing in this case.
This is a new day, though, Your Honor. This is a whole new day.
That is ridiculous.
On my part, to give you some guidance before you potentially do that in front of the jury.
Okay,
but you're right. I will wait and see.
Your Honor, it's
But
still,
I need to get going.
it's still
and I'm going to,
unconstitutional for you to
sir.
tell me that
You
I don't
need to
have
be
the First
quiet.
Amendment right that I preserved, or the Sixth
Mr.
Amendment
Brooks,
right
I'm
that I
going to have
preserved.
the jury brought out. I expect that you will be respectful, courteous, and quiet.
Or I'll be
And
held
when
in
this door
contempt.
opens,
Or I'll be held in
if
contempt.
you insist on making remarks, then I will excuse everyone from this courtroom and you will be removed because you will forfeit your right to be present for being disruptive.
Under what lawful law?
That
Because
is
I
my
haven't been
ruling.
dishonorable to the court.
Madam Clerk, please have the jury brought out.
Well, take me to the next courtroom then. Take me to the next courtroom, because you're not going to override my constitutional rights just because you feel like you can, and you don't have no lawful law to do that. We all have constitutional rights, and you cannot trample
Mr.
on
Brooks,
those.
what you are raising are essentially issues that you can raise on appeal.
No, I'm raising them now because they need to be on the record now. Because you won't allow me to make the record as I've let you do. You've even went so far as to mute
Mr.
me.
Brooks, the
Which you
jury
can't
is
even,
coming
there's no
out.
lawful law to say that you
I'm
can even
advising
mute me.
you to be quiet. They're coming
Your Honor,
out.
does Illinois versus Allen say that you can utilize the mute button? It does not.
Mr. Brooks,
So
when
you're-
the door
you're-
opens, I expect you to be quiet.
You're,
and you will
you're,
forfeit
and I
your right
expect
to
for
be
you to,
present.
I expect for you to answer questions as a public servant, Your Honor. You're a public servant.
jury's coming
You're
in.
supposed to serve the people.
All right.
Take me to the next courtroom. Please, take me to the next courtroom. Hold me in contempt.
Yeah, let's go ahead
Hold
and
me in
do that.
contempt. Hold me in contempt. Hold me in contempt.
Nice.
I have constitutional rights that are being trampled on, and you're coming up with ways to make a lawful law where it doesn't say in Illinois versus Allen anywhere about utilizing
The
the
records
mute button.
reflect that the jury bailiff is in here. However, the jury is still in the hallway. I'm going to give Mr. Brooks one more opportunity to be respectful.
No more
of the court's
opportunities.
rulings, whether
Your Honor,
they
That's
agree with
over.
them
I
or
haven't
not.
dishonored the court. I'm merely exercising my rights under the Constitution, under the First Amendment, and under the Sixth Amendment.
Mr. Brooks, your rights do not include you disrupting these proceedings
I'm not
the way
disrupting
that you have through
the
the course
proceedings.
of
You just
3
told
weeks.
me you don't have to honor my constitutional rights in so many words. You're using a mute button
Mr.
that's
Brooks,
not
the
even in your
jury
decision.
is outside this door. They're not brought in
I'm
yet.
informed that
I'm
the jury. I'm
asking
informed
you
that the jury
to
is
be
outside the
respectful
door.
of their time.
They're not in the courtroom.
I'm
They're not
asking you
present.
to be respectful of the court's ruling,
They're
whether
not
you
present.
agree with
These
it
are
or
issues
not.
that need to be resolved before they're present.
Mr. Brooks, they will not be resolved to your satisfaction.
It's not about my
The
satisfaction.
record
It's
has
about the
been made.
Constitution. It's about what's right.
Are you going to
Are you
follow
going to
the
answer
court's
questions as a public
requirement?
servant on why you're making up laws that are not in the Illinois versus Allen? It never utilized
the
the
jury
mute button.
can
It
go
never
back
said
to the
anything
jury.
about a
Thank
mute
you.
button.
It is clear
Why
that
am I
Mr.
being
Brooks has
muted?
absolutely no intention of following the simple rules of decorum and courtesy. He has repeatedly talked over me. He's repeatedly interrupted. Even though I've made rulings, he's not respectful of the fact that I made a ruling, even though he disagrees with it.
How can you
I
make
attempted
it?
to bring the jury out,
How can you
and
utilize a mute
he
button?
continued to talk.
That's
So, Mr. Brooks, you
Your
have
Honor,
forfeited your right to
is
be
that-
present for the state's
is that
closing
not?
argument.
Your Honor,
You will
can
be
you answer
taken
this
to
question?
the courtroom next
As a
door, and I
public
will
servant-
invite you back over when it's time for your
You can't
closing
invite me
argument.
back over. I can reclaim my right. So how can you invite me
All
to do
right, the
anything?
courtroom is to be cleared so that Mr. Brooks can be removed to the next courtroom, and I'll make appropriate findings when he's in the other
Yeah,
courtroom when I
and
can
you'll
do
mute
so
me, which you
without
can't lawfully do.
interruption.
You can't lawfully mute me. So now you're trampling over my First Amendment rights.
Alright, so just Darrell being Darrell pretty much. Yeah, he knows it's over, so he got himself kicked out once again. And just based on the way he's acting right now, I'd imagine his closing argument is gonna be just insane. I saw she said they have an hour carved out. I expect him to take the entire hour. Like, he's not a person that's difficult to read, even though he thinks he is. But yeah, I'm gonna call this one here, and in the next one, we're gonna get to the prosecution's closing argument, followed by Darrell's closing argument. Unfortunately, if he does one. But seriously, from the bottom of my heart, I want to thank you all so much for continuing to watch my stuff, because I've been super inactive lately. So if you all saw my community post, I basically encountered a next door neighbor that was exactly like Darrell. I mean, he was just as unhinged, just as crazy. I want to thank you all so much for even sticking around through all that, and I hope now like I can just do a ton of videos. Like, I want to have like an actual schedule, and I'm sure I've said this before, so it feels weird saying the same things, and I'm sorry sorry for doing that to you all, but I mean, at this point, I'd rather just do it and then you all can see the work. So that's what we're gonna do. I want to say thank you. I love you all so much. I hope you did something good for somebody today. I hope somebody did something good for you, and I will catch you all in the next one.